bills, and I don't know that I'm going to go for sure in the order that they are. You can keep notes if you're interested. 1207. If you remember a few years ago, the feds said that you can withhold, in fact, they mandated that you withhold licenses from those who are delinquent in child support. I think the threshold that kicks that in is like 1,000, and if you're that far behind, in order to keep your license, driver's license or whatever, then you have to enter into a payment plan, so you go to work on those. There's some legislators that are trying to have that repealed. I think it'll go down, but that was heard yesterday in Appropriations Committee, and I couldn't see when I checked today what they did with it. My guess is that they're holding it, and then I think that the Appropriations Committee will kill it. I was working other bills, which I'll get to here shortly, so I did not attend the Appropriation Committee hearing, but I'll check with them next week and find out what's going to go on. Anyway, that's 1207. That's interest. Senate Bill 139, that was amended, and that's simply a kind of a latches where if the mom and dad who are divorced, and if they informally change custody for 120 consecutive days, that the parties have deemed to make that the new agreement. And the language is a little bit awkward. I made a suggestion to the sponsor that maybe they want to clean up the language. They did so. That was amended, and it's through the Senate. It'll be going over to the House for its consideration. Essentially, all that does is say that latches attach after 120 days. It's not final. When I talked with the sponsor, I explained, well, what if mom's mother's dying of cancer? And they said, I've got to leave, go up to the Twin Cities. I'll be back. You take Junior. And so they come back 5 months later. That shouldn't mean that mom is just totally out. So the way the language reads now is there's a rebuttable presumption. Mom could come back in and say, look, here's the emails. I said, this is for until mom dies and we get done with the funeral. You're going to need to watch Junior. So the custodial parent who for 120 days gives that up for a particular reason will have an opportunity. That parent who has taken custody for that 120 days gets the benefit of the presumption. In committee, and I wasn't working that particular bill, but in committee I was called to explain the ramifications of the bill and its language, and so I simply explained to them the concept of latches, that it's similar to a statute of limitations, except that latches simply means you sat on your hands too long, as you remember from your law school. So that's 139. It's over on the House side, and I think it will probably go. Now we go to a series of a number of what I'll call the shared parenting advocates for longer than I can remember, certainly close to 20 years. We've had what I sometimes refer to, and I understand that some people are offended by it, but I'm in my last year, so what are you going to do? I characterize them as the Mad Dad bills. In any event, Senate Bill 140. The intent on 140, well, and I can tell you, they also had 165, and that has to do with the enforcement of child support, and then 167, which is your traditional shared parenting, rebuttable presumption. The bill would call for shared parenting, but the objecting parent would have the burden of by preponderance to defeat it. And then there's a couple of House bills that likewise were in there. So, and this was moving very, very, very fast. And so what happened was Wednesday night, about 6 or 6:30, I got an email from the committee saying, we hate all these rebuttable presumptions, etc. But they didn't have time to give me language that they thought would fix the bills. I suppose indirectly you could say that means they're all on the kill list. Well, I sat down with the prime sponsor. These were Senate bills, except the prime really is Representative Pischke over in the House, and he was the prime last year on the shared parenting. What he was trying to do with 140 is where both parents were very actively involved in the child or children's lives. But you file for the summons and complaint, and so let's just and recognize that you can switch roles, but I'm just going to characterize it as mom and dad, so I don't have to keep saying he/she, etc. The court enters the order of temporary custody, and let's just say it goes to mom, subject to dad's traditional guideline every other weekend, that kind of stuff. And under current statute, they can object, and they get a hearing. But the true, in most cases, they're going to sit until the final adjudication, which could be 6-8 months. In the meantime, the non-custodial parent is getting a fraction of parenting time in the face of where they had taken a very active role. Talking with the prime sponsor, I said, we're not interested in a do-over where every waking minute that dad wasn't working, he was on the golf course, he was hunting, he was fishing, he was watching football on TV or whatever, and then all of a sudden with the pending divorce is now I want to be a good dad and I want to be involved. The standard guidelines probably is appropriate for that, but what about the one that literally, by moving out or being required to move out, why should that non-custodial parent get the limited parenting time that the one that was selfish and looking out for their own pursuits? So what we tried to do is redraft 140 to have the custody order, the temporary custody order, reflect the, to the extent possible, the amount of active participation that's provable in that non-custodial parent, on the part of the non-custodial parent, in the child's life. And that's what we were endeavoring to do. So 140 was amended in committee. I suppose in retrospect, the language of the amendment is a little bit obtuse, but we were trying to work on 6 bills inside of an hour. I got to the Capitol, like I said, I got this Wednesday night and I worked Wednesday night on it, met in the Capitol at 8 o'clock. They held the hearing because they were coming up Thursday morning. And those 3 bills, 140, 165, and 167, they were all coming out. The vote was going to be either 5-2 or 4-3 do pass. And I didn't want to miss the opportunity to influence at the Senate level because otherwise I would know they're just going to come over the House and I got one last shot to carry out the intent of our profession and so forth. And the bar commissioner said, go cut the best deal you can get consistent with the general instructions that we got. So anyway, that's what happened on 140. It's been amended. You need to look at it if you do family law, and maybe that language can be improved. There's the amendment kept some of the language that comes at the end of Senate Bill 140, and it talks about maximizing the non-custodial parent's time, and I didn't see that as inconsistent with if you read it in conjunction with the new statute that talks in terms of trying to get the non-custodial parent with that share of parenting time that they had demonstrated up until the time of the separation of mom and dad. That was our intent. And we thought if you read the two together, the court will get it. There are some lawyers, judging by some of the emails, that say, no, now we've got two different standards and it's confusing, etc. I did the best I could. And maybe some lawyers can tell me or give me better language, but what we're trying to do is take care of those people who are active in the kids' lives, but where they can't, perhaps it just simply doesn't work to have the 50-50 or substantially shared equally time. So there, we were trying to give the court some direction of in between. That was our intent on 140. But part of this deal was that I was going to cut a deal on a whole bunch of these as kind of a package deal. So then we went to 165, and that primarily deals with the enforcement of child custody / visitation. And, the bill would have introduced language that talked in terms of the duty of the custodial parent to facilitate the visitation. And I suspect if you got, 50 judges in the room, every one of them come with a different interpretation of facilitate. I know that we'd have, if 50 lawyers would have a hell of an argument trying to agree on what that means. And I said, that won't work. But then I got the idea. That with 50% or better of all divorces now are pro se, and while I recognize that ignorance of the law is no defense, how did these people learn that it's important that they follow the terms of the visitation order? And so we gutted that first section and simply said every child visitation or custody order, they will staple to the back a copy of the statute that says a willful violation of the court's order can result in the following, and it lists about 7 options or sanctions that the court can impose. And I thought, this is great. Every single order in the future, the people, when they have that order in hand, are going to say, and if you don't follow this, these are the possible ramifications. So we think that the sponsor thought that was a great idea. I thought it was great. And so that's going to be part of 165. Section 2, we simplified it and just said, if you believe, as the non-custodial parent, if you believe that your rights have been violated, you can simply make the motion to the court. And then the sanction list, which is 254A5, we changed the bill a little bit, and we give the court the authority to enter an order clarifying the rights and responsibilities of the parents and the court's order. I characterized it in committee as you're both going to the principal's office, and the principal is going to explain the facts of life. And in this case, the principal would be the judge. So the judge can clarify, and then it kept the existing 6 principal sanctions that are already in the code, and then we added a 7th one. They wanted to, the sponsor wanted to have the court to be able at that hearing to go ahead and order a switch in custody. And reading one of the emails from the Family Law Committee, they were concerned that somebody would show up, the custodial parent, with the idea that, yeah, I'm going to get a lecture. Maybe they'll even make me pay a couple $100 in my ex's attorney fees. And then, lo and behold, they aren't prepared, and the judge flips the custody. And they were concerned that that could happen. And so what we did is we got rid of that language. Well, we maintained it, but here's what we did. We inserted the language, if it was an aggravated violation, custodial parent disappears for 18 months on the run, when they finally get them back into court, I assume the judge is gonna flip the custody under those circumstances. So if it's aggravated, or if there are multiple violations, then the court may modify the existing custody agreement. And then the last one is, the last section of that simply says that the UJS will maintain a form to make it easy for the parent who believes their visitation. That's already, UJS, it's already up at the website. It's Form 386, if I remember correctly. Anyway, so that was amended. I think that we got rid of the bad language and actually are going to do some good with that. 367, your traditional shared parenting bill, is going to be amended down, and was amended down to almost nothing. It added about, well, on page 3 of the bill, 15, 16, 17, 18, 19, 20, 21, 22, 23. Additional things that the court should look at when it's weighing the request for shared parenting and how to apportion custody of children. And all of them are probably already considered by the judges in any event. And so we didn't see any harm in that. All the rest of that bill was gutted and disappeared, so you can look July 1st for some additional criterion that the court will be considering. But the stock historical shared parenting bill is dead. That was part of the package deal. The other thing that I can tell you, if you're looking at them, is House Bill 1208 that deals with child support and arrearages, and House Bill 1212 that again goes back to mandating that the parents at the beginning or during the course of the divorce have to develop a parenting plan. We've killed that year after year. Most divorces don't need it, but don't need a shared parenting plan because they've already worked out how they're going to do it. So those two bills, 1208 and 1212, are going to disappear. The sponsor will go in and he will table those. And so that's kind of the package deal with the family law. Couple bills that you might be interested in. House Bill 1204. That is revisions to the power of attorney. That's a uniform law. It's primed by Representative Lust. He's on the uniform law. He is a uniform laws commissioner. He may even be the state chair. I don't know. But anyway, that's a uniform law. Kind of thick. But that's one that you could watch if you're particularly interested in. And then Representative Johns brought the Uniform Unsworn Domestic Declarations Act. That's House Bill 1085. Both of these have already gone, 1204 and 1085 have gone through House Judish. I think they were both on consent, probably maybe even enacted or approved by the House, maybe even today. But those are just, that's informational for you. A couple more. Senate Bill 145. Senate Bill 145 in essence would take bad faith claims in workers' comp and would take it out of the court system and send it over to the Department of Labor. That will be one of the hottest contested pieces of legislation this session. You've got insurance and employer organizations that want that, and of course trial lawyers hate it. You folks can read the bills yourself. It is a dramatic departure from our current system. I have no directions on this at all, and so I'm not working it. I don't know if the bar commissioners are going to consider it. They probably will be talking about it. I can tell you that some of our members have been asking the commissioners to order them to go in and kill the bill, and other members are contacting commissioners saying The state bar doesn't belong in on this fight. Keep Barnett parked. As you know, I just wait for orders. So that's one to watch. For those of you perhaps out in the hills that do deal with severed minerals, you might want to keep an eye on Senate Bill 171. I'm not going to bore you with it. The people that do that kind of work, it's 171. Take a look at it and follow it. 172, if you caught the governor's State of the State address, he talked about either the need or how appropriate it would be to have a compact with neighboring states to allow people to freely move in and give them the authority to practice their business or their profession for up to 18 months before they secure South Dakota licensing. There's a lot of opposition to that coming from, and I don't have a dog in the fight, but coming from doctors, dentists, CPAs, those kinds of folks. I'm watching that one carefully. Yes, we're a profession. Does the language of the bill, is it broad enough to cover the legal profession? I think it is. But the difference between us and all these other licensed professionals is we have the Constitution. And the Supreme Court decides who gets to practice law in our courts. So I know that the Chief Justice and the Supreme Court are keeping an eye on that. I'm not part of any negotiations with Second Floor on that particular bill, but until it's resolved, it's on my watch list, and so I'm bringing it to your attention. Things are moving fast and furious now up there, and so it'll be very busy. I will be giving you updates every Friday, maybe a Thursday afternoon, depending on which 4 days they decide to work. But I'll give you the updates as they occur. Thanks for tuning in. Have a good weekend.